Today we are discussing about one of the most important and most commonly faced problems in Indian law. What do you do when the police simply do not act? Your FIR is refused, your complaint is ignored, weeks pass, months pass, and the person who wronged you is walking free while you keep going to the police station and getting nowhere. Hello friends, I am Advocate Sudip Patra, practicing in the Supreme Court of India and the Calcutta High Court. In today's video, I want to give you a complete, practical, step-by-step guide what police inaction actually means in law, when exactly you can approach the Calcutta High Court, what the constitutional remedy is, how the process works from the first day you file your petition to the day the court issues its order, and critically what can and what cannot be achieved through a writ petition. I want to be honest with you about all of it, because false hope does not help anyone. But I also want you to know that if your situation qualifies, the Calcutta High Court is one of the most powerful instruments you have, and it moves faster than most people think. This video is especially important if you are in West Bengal, if the police station is in Kolkata, or anywhere in the state, and if you have been told there is nothing you can do. There is. Let me explain exactly what it is. Let us start with the basics. What is police inaction in legal terms? Police inaction is the deliberate or negligent failure of the police to perform their statutory duty. The most common form is refusal to register an FIR. Under Section 173 of the Bharatiya Nagarik Suraksha Sanhita, the BNSS, which has replaced Section 154 of the old Code of Criminal Procedure, the moment you give information to the police disclosing a cognizable offense, they are legally obligated to register it. No preliminary inquiry, no come back tomorrow, no it is a civil matter registration is mandatory. The Supreme Court of India settled this completely in the landmark judgment Lalita Kumari versus Government of Uttar Pradesh, decided in 2013 by a 5-judge constitution bench, the highest possible level of judicial authority, below only a full bench. The Supreme Court held in unambiguous terms that registration of FIR for cognizable offences is not discretionary, it is mandatory. An officer who refuses is acting unlawfully. Now, there is a nuance here, and I want to be transparent with you about this. For a narrow category of cases, matrimonial disputes of a civil nature, pure contractual matters, cases where the facts do not on their face disclose a cognizable offense, courts have held that mandamus will not be granted because there is no statutory duty being violated. But for the vast majority of genuine criminal complaints, assaults, criminal trespass, cheating, extortion, criminal intimidation, domestic violence, land grab involving violence, FIR refusal is indefensible. And if you are unsure which category you fall into, that is exactly what a good criminal writ advocate will assess for you before you spend time and money on a petition. Let me give you a real world scenario. So this is not just theory. Imagine Rohit is a small businessman in Kolkata. He had a business partner who defrauded him of 40 lakhs, forged his signature on documents, and transferred company assets without his consent. Rohit goes to the local police station with all the documents. The officer in charge of the police station looks at the papers and says, "This is a business dispute. Go to civil court. We cannot register FIR." Rohit goes to the superintendent of police and sends a written complaint. 1 week passes, 2 weeks, no response. Now what? Rohit comes to us. We assess the facts: forged signature, fraudulent transfer, criminal breach of trust. These are cognizable offences under sections 316, 318, and 338 of the Bharatiya Nyaya Sanhita. FIR refusal here is not just wrong, it is unconstitutional. We draft a writ petition under Article 226 inches, the Calcutta High Court, naming the officer in charge of the concerned police station and the state of West Bengal as respondents. We attach Rohit's written complaint to the police station, his registered post receipt to the SP's office, and an affidavit outlining the facts and the criminal elements disclosed. We file the petition and apply for urgent listing. Within 1 week, the HC lists the matter. On the first date, the court issues notice to the respondents and passes an interim direction asking the officer in charge of the concerned police station to file a response within 10 days, explaining why FIR has not been registered. The officer in charge of the concerned police station lawyer, represented by the state government, comes to court, and on the next date, the officer in charge of the concerned police station is directed to register the FIR within 7 days. The FIR is registered. Investigation begins. That is what a writ petition achieves. Not just in theory, in practice, in the Calcutta High Court, in cases exactly like Rohit's. Also consider a scenario where an FIR has been registered and no action has been taken against the accused by the concerned police station. And the investigation officer and the accused persons are constantly threatening the complainant to withdraw the particular police complaint. And though, irrespective of the clear evidence where custodial interrogation and arrest of the accused person is necessary, the police is not arresting them. We moved a writ petition in this regard, police inaction writ petition, and immediately court ordered to ask for a status report that when the police has conducted any kind of raid to arrest these persons, and immediately the accused persons were arrested by the investigation officer in full compliance of the high court order. So not only for the registering of the FIR, but at any subsequent stage where the police is not acting in accordance with the law, you can also move such kind of writ petitions in the Calcutta High Court. Now let me walk you through exactly how this works, step by step, so you know what to expect. The first thing you must do before approaching the High Court is to give a written complaint to the officer in charge of the concerned police station. Write it clearly, state the facts, name the offenses if you can, and keep a copy. The second step, send a written complaint to the superintendent of police of the district by registered post or speed post. Keep the receipt. These two steps show the court you made genuine efforts before approaching them. The third step, which can run parallel, file a complaint before the concerned judicial magistrate under section 175 of the BNSS, asking the magistrate to take cognizance and direct the police to investigate. The fourth step, if urgency demands or if you have waited a reasonable period and there is no response, file your writ petition under Article 226 inches the Calcutta High Court. Your advocate will prepare the petition, the supporting affidavit, the wakalatnama, and in urgent cases, an application for urgent listing. The petition names the officer in charge of the concerned police station, the SP, and the state of West Bengal as respondents. You pray for a writ of mandamus directing the officer in charge of the concerned police station to register your FIR and investigate within a specified time. Once filed, in urgent matters, the court can list the petition within 1 to 3 days. If the court passes an interim order and the police do not comply within the time directed, your advocate files a contempt petition, and a police officer who ignores a high court direction faces serious consequences, including personal liability and imprisonment for contempt. The entire process from petition filing to first order typically takes 1 to 3 weeks in the Calcutta High Court for genuine urgent matters. Non-urgent matters are listed in the normal course, usually within 4 to 6 weeks. Before I close, I want to tell you about some of the other reliefs you can ask for in a writ petition against police inaction, because it is not just about FIR registration. If your investigation has started but is going nowhere, witnesses not examined, evidence not collected, charge sheet not filed, you can seek court monitoring of the investigation, and the HC can direct police to file periodic status reports to the court. If you believe the local police are biased or compromised due to political influence, you can pray for transfer of investigation to the CID of West Bengal or the CB-CID. In very rare and serious cases, high-ranking officials, large-scale organized crime, or communal violence courts have even recommended CBI investigation. If police have taken retaliatory action against you and registered a counter case to intimidate you, your advocate can seek a stay of that case and raise the retaliatory conduct as an additional ground in your writ petition. And in cases where police inaction has caused you demonstrable harm, prolonged harassment, physical injury, financial loss, you can include a prayer for compensation against the state of West Bengal under the public law remedy principle that the Supreme Court recognized in Neelabati Behera versus State of Orissa. Friends, the bottom line is this: police inaction is not the end of the road. It is the beginning of a constitutional journey that the framers of our constitution specifically designed for situations like yours. The Calcutta High Court under Article 226 is that forum, and it has the power and the willingness to act. Please like this video if it was helpful, share it with someone who needs it, and subscribe to our channel for more practical legal guidance like this.